Well, let's get started. Okay, so again, welcome. Estate planning made simple. What is a trust? I've been doing estate planning for a while, and this is the one question that seems to come up quite a bit. What is a trust? And so I said, you know what, let me create a presentation focused just on that aspect. Estate planning has many pieces to it, but we wanted to make sure that, instead of confusing individuals with putting everything in one type of seminar, that we're like, let's focus on one topic at a time and really just want to make estate planning as simple as possible. So I started this series, so stay tuned for other presentations that will come to talk about particular aspects of estate planning. But today we're going to start with specifically what is a trust. All right, so let's get started. First of all, let's start with a case study. Aretha Franklin, one of my favorite artists, Queen of Soul. Some of her greatest songs, ever made were made by her. Let's see, some of those: Respect, Chain of Fools, I Never Loved a Man the Way I Loved You, Who's Zooming Who, Dr. Feelgood. I'm sure you guys have favorites. You can throw those in the chat if you like. But definitely, she had a great career, great talented person. Her career spanned all the way from the 50s until the early 2000s. I don't know if there's an artist that can really equate to her. But over her lifetime, but when she died, her estate was valued at $80 million, right? $80 million. Definitely well deserved. She definitely was a talent, and she definitely used it quite well. But she didn't have an estate plan in place. After she died, they found a handwritten will, which can be valid. But I think they found more than one. So trying to decide which one was correct, and then the different challenges that can come up in that situation. It took over 5 years in order for them to really settle the account. All that time, the money is frozen, cannot go anywhere until it's resolved and finishes the probate process and all the challenges that came. And that caused a lot of legal fights. Taxes had to come into play. It drastically reduced that $80 million to a lot less. I tried to find an accurate number. I don't like to push forward false information I don't know to be true. But in some places, I saw that the estate, by the time it was settled, was as small as maybe $8 million, which, I mean, for us, that's fine. I'll take it. But just the idea that because she didn't have a robust estate plan in place, instead of her heirs, her beneficiaries, her children, whoever it is that she wanted to have her riches to go to, they got a fraction of what she was really worth. And so the impact that she's had, yet the people who are her children's children are not necessarily benefiting fully, just because she didn't have an estate plan in place. So this is just one example. Just wanted to again show you the impact that an estate plan can have or cannot have if you don't have one. And I could have picked her. I could have picked Prince had a similar situation. James Brown had a similar situation. All these things, great individuals. They amassed great fortunes. But they did not have a robust estate plan in place. So now it caused chaos, a diminishment of their estate in legal fees and taxes because there was an estate plan put in place. It's just an example. And sometimes I'm cautious in giving these examples too. I just use it because we know the celebrities. So hopefully it kind of can resonate. But I don't want to continue to the false notion that estate plans are only for the wealthy, because that's not true. This is just an example. Every adult needs to have an estate plan. What is in the estate plan depends on exactly what your status is and what your situation is, but everyone needs an estate plan. But we'll get into that. This is just an example. So going to the next slide. We talk about estate planning. It's nothing new. Maybe it's something new that, we kind of see on the social media a bit. We see this concept of trust there a little bit, and a lot of these terms that are out there. But this idea of estate planning is nothing new. You go back to the scriptures, and Proverbs 13:22, a good man leaveth an inheritance to his children's children. right? So let that sink in for a second, right? I mean, it goes all the way back, as far as the foundation to the scriptures, that this is wise advice, from the book of Proverbs, from King Solomon, through the scriptures, that, that's something that we should be thinking about, not just about our lifetime and the things that we need to do to make ourselves comfortable, but what are the things that we're doing in order to make sure our children and our children's children are comfortable. So the idea of estate planning, inheritance, planning for the future of your descendants is nothing new. I think, the one of the concepts is that to make sure that not only do we think about it, but we put the right things in place so that they can be carried out in the way that we think they will be, because we won't be there to make sure it happens. So how can we ensure that our goals of making sure my children's children receive so and so actually happens? Go back to Aretha Franklin. $80 million worth of her estate was valued at that amount at her death. She had her handwritten will in her mind. She's thinking she's carrying this out, taking care of her children's children, or whoever the beneficiaries were. Little did she know, in her passing, that they would take 5 years before it settled, and that so much money would go into other places. And that's why it's important that you connect with an estate planning attorney, talk about your specific situations, and then make sure that the right pieces are put into place so that things are safeguarded, and that even if you're not here, is taken care of, right? You can have peace of mind about that. So let's keep going. And the concept to kind of put all this into place is generational wealth, right? It's the idea is that whatever I'm accumulating during my lifetime shouldn't just die with me, right? You say that you can't take it with you, but the idea is, okay, well, while it's here, where should it go, right? Do you want to go into the government? Do you want to go into creditors? Do you want to go into like fraudsters or anyone else? Or is it that, because it's generational, right? Is it that you want to build it, whatever it is, $10, $100, $100,000, $1 million, whatever it is that you've built, when you pass, don't you want that to go into, however you want it to? It could be to your children or to your nieces or nephews. It could be to a charity, whatever it is. The idea of transferring wealth, you have control of how you want that to happen if you do it in the right way. So there's two phases to generational wealth. The first piece is accumulating wealth, and you're going to do that through going to school and getting educated, following your career, whatever that is, investments you may go into, the stock market, buying a home. And most people, their primary home is going to be their largest asset. Other real estate for investments, entrepreneurship, starting a business, assets, Bitcoin, whatever it is in building assets, during your lifetime, you're going to build it. It's going to serve you, send your children to college, acquire things like that. But again, like you said, you can't take it with you. So the question is, well, what do you want to have happen with that? A will is insufficient, right? That's one piece of it, but that's insufficient. And we're going to see some of the examples of that. So the concept of estate planning is, well, how do you want to have that wealth transferred? That's what estate planning is. And different aspects of that is a trust, which we'll talk about in this session, a will, which is still valid and necessary, but it may not be adequate in order to fully have your wishes carried out. Business succession, if you have a business, what happens next? Life insurance, we all should have life insurance. Cultural legacy. A part of this is also, as we're passing on, one of your biggest assets is not necessarily your things, it's you. It's the things that you've learned. It's the values, right? It's the standards that you hold there. Also, passing those on is real important as well. And beneficiary designations, who should, for things that maybe can't go into a trust, how would you handle those things? My point is here, I just want to make sure that you can kind of think of this, in two pieces. One, you have the phase where you're accumulating your wealth. Estate planning is about, well, what happens next? Okay. All right, let's go into the next one. And again, any questions, comments, thoughts, put them in the chat and we'll get to it. Okay, so what is estate planning? Here's a legal definition. Here's a general dictionary definition. Estate planning is the vital process of legally documenting. And that's important, right? It's not just what I told someone or what I think should happen, but it's making sure that it's legally documented. And it's more than just documents, but it's a strategy to protect your wishes, your assets, and your loved ones, right? And this is important. It's during your life and beyond, not just when you die, but also if you become in a state where you're not able to manage things yourself, who's going to manage them for you? You don't want to leave that part to chance either. And you want to make sure, again, this is the part of securing your legacy and ensuring that you have peace of mind for those who matter most. So again, it's sort of like, making sure that, again, when you're not here to manage things, how will they be managed to make sure that, your children's children or whoever else that you want to have as your beneficiaries, have the things that you want them to have. All right. Okay. That's estate planning. And the value of it, again, is not having an estate plan, as we saw from that one simple example of Aretha Franklin. Legal issues, which ate into the assets, and so that by the time it was all done, the lawyers got it. Which, as a lawyer, I'm not, understand. We got to earn a living, but the lawyers got a lot of that, more than the actual beneficiaries. I'm sure that was not in the concept of Aretha Franklin's goals, but that's what took place. The taxes took a lot because it wasn't structured properly, as well as legal fees and the fights that they had in trying to resolve the estate. Family, personal impact, the disputes among the family, making sure the guardianships are, if you have minor children, are being taken care of. Few generations lose family values. It can be exploited. Financial consequences, each generation starting at zero, right? I mean, the idea is we're hopeful that we're giving our children a step up from where we are, so each generation can continue to build upon that generational wealth and not have to start from zero or negative. So if you don't have a estate plan in place, all these things are at risk. And it just makes sense when we have, especially in this day and age, resources that are available to us, the knowledge that is there, things that were at one time may have been hidden or not very clear. Now it's very clear that there are steps that we can take in order to protect yourself. All right. So again, just to reiterate why estate planning is important and how a trust fits into that. It ensures your wishes are honored. Make sure you protect your loved ones and your assets, minimize taxes and avoid legal hurdles, plan for not just your death, but also incapacity of disability, right? Many of us will, and who knows, but many of us will not just live and then die. Many of us will live and probably go through a period of disability, of incapacity, right? So, whether mental or physical. So, what happens then? An estate plan also answers that question. Avoid family disputes, provide for minor children, right? Secure for your business legacy, support charitable causes or churches or any things that you may want to do, maintain your privacy, which can be important too. We'll jump at that in a second, and save time and stress. That way you take care of it, it's set aside, and it's ready now that no matter what happens, you feel like, okay, at least they're taken care of. And I know I've done my part, not just in acquiring, but also doing my best to make sure that it's transferred to the next generation, legally, securely, and I'm protecting their future as well. That gives you peace of mind. All right. So key elements to an estate plan. One of the biggest cornerstones of that is a trust. In this case, we're talking about revocable living trust, which we'll go into more detail about this. A lot of this is context. There are many different types of trust, but this particular one we're going to be talking about today. A will, which people are pretty familiar with what a will is. Power of attorney is also a part of your estate plan as well. Healthcare directives, to understand, again, if you become incapacitated or disabled, you have a document or individual set aside that can kind of make those type of healthcare decisions for you. So these are all part of our comprehensive estate plan. These are the basic building blocks. There are more pieces as well, but these are, if you don't have anything, you want to make sure you have at least these things in place. And we're going to, as we go into this series about making estate planning simple, I'm going to go more details on all these pieces. So, but for right now, we're going to be talking about a trust and sort of how it fits into an overall estate plan. So the idea about a trust is that, again, it's nothing new. It's been around for quite a long time. I think it's probably for the past 50 years, let's say, it's become a little bit more prominent, especially when it comes to middle class. but ultra wealthy have been using them for years. And so it's the idea that now they've become a little more structured in a way that makes it more useful, I think, for those middle, upper middle class, so on and so forth. So why they're important is to kind of think about, it's kind of like a will, that it's a legal document that speaks about, what do you want to have happen just in case. And in a trust, it's like, and in case of incapacity or death, but it has a little bit more features in it, a little bit more protections that are in a trust. So where a will fails, wills are great, and we still need a will, but wills have to go through probate court. Many people don't realize that. Many people think, if I have a will, well, that's it, I'm done. I don't have to worry about the legalities of the courts getting into my business. But the truth is, if you have a will, you definitely have to go to probate court. The job of the probate court is to probate, to prove that the will is correct, to prove that the will is valid. And so they would examine the will, and if you've had an executor set up in it, they will examine it to see if that person is fit in order to do that. They will publish it; it'll be public record. Creditors actually go to the probate court, so a surrogate courts in New Jersey, to kind of see who's died and who do I need to go and grab some of their money before they give it to the beneficiaries. It's a public thing. And if you have a will, you have to go through probate. Also, a will does not provide for incapacity, right? So a will is, when you die, I bequest this to so-and-so, I bequest this to so-and-so, but it's very silent. It's not useful during a time of disability or incapacity. So that a will doesn't do that. It can be problematic when it talks about crossing state lines. So if I'm in New Jersey, I own property in Florida, I own property in Missouri, I own property, whatever, you have to go through probate in every single state if all you have is a will. Right. And it's pretty much capture a point in time. When I die, give so-and-so this. When I die, give so-and-so that, and that's it. So if you have children that are minor or maybe 18, it's like, and you have assets that you want to give them, a house, something like that, it just goes straight to them. That's it, done. There's no control over how it's given to them or when it's given to them. It's just given to them as soon as the estate settles, when it goes through probate. Provide direction and protection for a short time at death. So it's just at one point in time. So these are just some of the examples where, wills are great, but a trust could be better. And let me just show you exactly some of those aspects of that. It's a list of revocable living trust. Revocable living trust is just a contract, very similar to a will. It's guided by statutes. Every state have statutes, controlling what a trust can and can't do, what the structure has to be, what some of the things have to be in there. It's notarized, witnessed, in some cases recorded, and so it's a legal document. But in that, it allows you to transfer assets into the trust once the trust is created, and then in that trust, in that contract, you're specifying how you want those assets managed and how you want to distribute it to your beneficiaries. So you're giving a lot more detail. So some of the benefits of that: avoids probate. It's private, right? Managing your assets during incapacity. So in your trust, it will specify, if I become disabled, this is what I want to have happen. This is who I want to have managed so-and-so. It can continue to be managed according to your wishes, even though you're not able to probably speak for yourself. And even though you haven't even passed yet. So the trust always does that. Control over asset distributions. Again, we're going to go into some examples. Protecting your privacy. A trust is a legal document, but it is private. It doesn't go to probate. It doesn't have to be published. So what you're doing as far as moving your assets from one generation to the other, only your family has to know. Only the people involved in the trust have to know. And it's a private thing, and that's real important to a lot of people. So there's a lot of different benefits here. You can try to read them for yourself, but I can kind of see it's really powerful. I think in the examples, you're kind of just getting a glimpse as to how powerful this is. And again, any questions along the way, any comments, anything like that, feel free to do that, to add that to the chat. Let's see. Okay, let's go on to the next one. So I'm gonna go through it's an illustration, right? So again, a trust is a legal document, right? When I create an estate plan for someone, put together a portfolio for them, and there'll be a lot of different pieces to it, right? It'll have your trust, you'd have your will, and these are legal documents. They're not cookie cutter. These are specified exactly to what a client will need based upon what they're telling me, the family dynamics, the structure, their goals, their assets, so on and so forth. And so, it's a legal document, it's a contract. And so, but conceptually, I'm gonna just go through this illustration to kind of show you how it works. All right. So there's different terms that are used. There are three main categories of people that are involved when it comes to a trust. The term that's used, at least in New Jersey, is a settlor, right? It could be a grantor, but blaming that's you, right? And you have some assets. You have real estate. You have your house. You have maybe some accounts. You have investments. Whatever your assets are, you have those, right? But again, you're called a settlor. So that's the first player that's there. And so the settlor is the person who actually creates the trust, right? And the trust, think of it as a bucket, right? It's a bucket that will hold your assets, right? But first thing that you do when you create the trust is that you're creating this bucket. You're creating the contract that says, I'm creating this trust so that I will be able to put so-and-so assets into it. But you create the trust, all right? And a part of that then is in that bucket is that, you also can specify who can control that bucket. And that term is called a trustee. Right, the trustees, and that could be you at first, right? You can be the trustee. And the beautiful thing about a revocable living trust is that because you created it, because you also will make yourself the trustee, it's revocable. I can take it back and start over for whatever reason, if need be. It's happening while I'm living. It's not happening, after I die. This is created while I'm living, so that way I get to take advantage of it, even if while I'm alive. You usually become the first trustee, but also within that trust, you will specify if anything happens to me, if I become incapacitated or if I pass, then I still want the instructions of the trust to take place, but I will have a successor trustee. That successor trustee could be maybe your spouse. It could be maybe a child, a responsible child. It could be a company in case. It could be whoever, someone responsible that will be able to carry out the wishes that you specify in your trust. So you have that. You have a settlor, which is you and your assets. You have the trustee, and all that is controlling that bucket. And so the goal, again, is that everything that you're setting up is for the benefit of the beneficiary. It could be your children. It could be, other individuals, or other friends or family. It could be a charity, whatever it is, whatever the beneficiaries are. That is who this trust is being set up with. All right, I got a question in there that said, how is your income tax filing affected if the house is in the trust? So the beautiful thing about a revocable living trust is that although and I'm gonna get to the house will be put into the trust, it doesn't change anything when it comes to that. It still would be a part of your estate. So it still would be a part of, as far as your taxes, as far as your homestead rebate, all those various things doesn't change. The only change is, as far as when it comes to your house, is the titling of it will be titled to the trust. But since the trust is you, all that will be structured under your umbrella. So there's nothing different has to happen if you set up a revocable living trust. All right. So once you create the trust yourself, you have a trustee, which could be your first trustee. Then you have successor trustees in case anything happens to you. You specify who your beneficiary is. We create this, and this is the contract that's written, and it gets notarized, it gets witnessed, and now it's good to go. But that's part one. The second piece now is that you have to fund it. And I'm pausing here because so many times, speaking to colleagues or even some clients where we go through this process of creating this trust, but then they forget to fund it, right? So it's not going to do any good until you fund it. And that's the next step, is to fund it. And that is sort of a part of the question that was asked. That's where you're actually will retitle it. So the house, which may be Jeffrey Blair, I'm on the deed of the house, now is the deed and ownership of it, the living trust of Jeffrey Blair, right? Or whatever name you want. It doesn't have to be that. It's anonymity. Sometimes you may use a different name, but it's in the name of the trust. But because of revocable living trust, again, it doesn't change anything as far as like your taxes or anything like that because of the structure of it. All right, so that's kind of conceptually. You have this bucket that you've created, you've put these assets into it, and now whoever is the trustee now manages it for the benefit of the beneficiaries. Now, If you notice, the part was the settlor. If I go away for whatever reason, either I'm incapacitated, disabled, or I pass away, the trust still exists. The items are still in the trust. And so now the trustee or successor trustee, whoever that is, will now carry out the functions that I had it laid out in the trust for the benefit of the beneficiary, even though if I'm not there. And this has, the power of the law, and it's set up in a way that will pass scrutiny. All right, so now let's go into some examples. Meet Sarah and James, right? So they're planning for their children's future, right? So Sarah and James have 2 young children, Emma and Jake. They're minors. They worry that if something happens to them unexpectedly, what will happen to the children, right? Which, as parents, common thought. So here's the problem. Of course, there's many things that will pass through your head, but here's one specific problem when it comes to estate planning. If Sarah and James leave their assets to the children through a will, whatever it is, it could be their house, it could be life insurance, it could be their bank accounts, their investments, whatever it is, because they're minors, right? The court will then appoint a guardian that would manage the money for them until they turn 18. And then at that point, at 18, then whatever's left in their estate, then they will just get outright, right? So Emma and Jane would receive their full inheritance regardless of whether they're financially responsible. So whatever that number is, right? It could be 100,000, 200,000, 500,000, whatever the assets are that Sarah and James have accumulated. When the children become 18, an 18-year-old getting that amount of money just like that, I don't know. I don't put a lot of weight that, I think very few 18-year-olds will be able to handle that, right? And who knows, after a few years, it probably will be all gone. And that's the last thing that, as a parent, you want to have happen. Well, this is where a trust can come in. Sarah and James could create a children's trust, which is, a variation of the Irrevocable Living Trust, naming Sarah her sister, Lisa, as trustee. And what the trust will do is it will pay Emma and Jake's education, medical care, living expenses. All this is detailed in the trust. It also will allow Lisa to decide when and how the funds are distributed based on the children's need. But also, instead of just giving them the assets outright, and when they're 18, you can stagger the distributions, right? You can say, Emma and Jake receive their portion of the assets. They get a portion when they're 25, maybe after they finish college. All this is detailed out. So this is how it would be done. And then another portion when they're 30, another portion when 35, instead of just having it all at once at 18, right? It's one example. It's one example where you can't do that in a will, but in a trust, you're able to really specify the details of how you want your assets managed and how you want to protect your children from themselves, right? Make sense? All right, let's go to another example. Okay, meet Brian and Michelle, and they want to protect their son's inheritance from divorce, all right? All right, so Brian is a retired engineer. Susan is a former teacher. They both worked hard their entire lives. They built a comfortable life. They own a home. They have a well-funded 401k, life insurance policy, bringing all the total assets to just a little over $500,000, right? Again, not the ultra wealthy, middle class, upper middle class, or depending what state you live in. So here's the problem, right? Everything seemed to be good, but here's the problem. Brian and Michelle have a son whose name is John. He's happily married for now. They like their daughter-in-law, but they've seen so many divorces turn ugly, right? Divorce rate, and what's the divorce rate in America? Is it 70%? I don't know. It's quite, right? So as a parent, you worry about that. They worry that if they leave their estate to John outright, and he gets divorced, half of their hard-earned assets will end up in the hands of his ex-wife, someone that's no longer a part of the family. I don't know if this ever crossed your mind. It's a common thing. Financial Planning Magazine did a poll, and it found out that some of their clients' biggest concerns for their wealth after they're gone is that someone will take financial advantage of their children or their grandchildren, or that they will lose a portion of their inheritance, through divorce. What can be done about that? Well, trust is a solution, right? Brian and Michelle can set up a revocable living trust that holds their assets for John's benefit, right? John would be the beneficiary. If John ever divorces and he keeps those assets in that bucket and don't commingle them with his own assets, his inheritance is protected because the trust keeps the assets separate from his marital property, right? It's powerful. John can still access the funds when needed, but his ex-wife can't touch them. Same thing goes for creditors, right? If John ever was to go bankrupt or anything like that, anything like that, or had an accident and someone came after him in a lawsuit, his personal assets, that he've acquired, definitely can be vulnerable to that. But whatever's in that trust is protected, right? So again, the idea is the trust can protect your assets, but also protects your children or whoever your beneficiaries are. All right. Hopefully this is making sense. Let me know if it's making sense. Let me know if you need something clarified. But I definitely want to make sure that these examples are bringing you value. Another example where trust can come into place, right? And these are just a few examples. Every situation is different, but that's one of the things that the power of a trust is, the flexibility of it. Meet Lisa, protecting her husband's legacy from a future spouse. All right. Lisa and Mark were married for 30 years, raised 2 children. Mark worked hard to build a solid financial future, leaving behind a home, retirement savings, and insurance policy. Like most couples, his will left everything to Lisa, right? Trusting she would later pass it on to their children. Makes sense, right? Here's the problem. After Mark's passing, Lisa eventually remarried. Without a trust in place, all of Mark's assets become part of Lisa's personal estate. And if Lisa passed away first, her new husband could inherit everything, potentially disinheriting Mark and Lisa's children. Right? And I've seen this happen, more than once. So the trust could be a solution to that. If Mark had used a revocable living trust with a marital trust provision, I don't want to get into that right now, but just understand it's the trust, a variation of the trust. Lisa could have received income for life after Mark died. She would end the trust and have the instructions that she would receive income for life, while ensuring the principal assets would go to their children upon her passing. So in this approach, allowed Lisa to use the assets during her lifetime, right? Prevented the new spouse from inheriting Mark's assets because it's in the trust and not part of Lisa's personal assets, and guaranteed that their children will receive their rightful inheritance. With a trust, Mark could have protected his wife's legacy, ensuring his assets stayed within the bloodline while providing for Lisa's financial needs. All right. So again, I hope you can kind of see the power of a trust in these examples. So just to recap, the power of a trust, much more powerful than a will. You have a lot of control during your life, but also beyond your lifetime. Dictate how and when assets will be distributed, even when you're gone. Protect your heirs from reckless spending, lawsuits, or in-laws. Flexible and customizable, designed around your unique family situation. All the situations are totally different, but yet and still a trust could be crafted in a way to fit those concerns and to protect, your heirs from, potential risk. Legal and powerful, it's backed by the law. Banks, courts, institutions, they must honor it, but it's also private. Avoids probate, keeps your estate confidential, out of the public record, shields assets from lawsuits, creditors, and necessary scrutiny, right? So a trust, control, security, and peace of mind, right? So generally speaking, that is kind of like what a trust is, how it's used, how it functions, and it's very powerful. So I want to make sure that I kind of share this information with as many people as possible to see how it could fit in to their estate plan. So what are the next steps? Next steps I encourage you is go to my website, jeffreyblairlaw.com. There's a QR code right there that you can utilize and start the process. It's 4 steps in order to get your estate plan in order. First starts with a free peace of mind planning session. That's where we get to know one another. I get to understand exactly what your particular situation is. What are your concerns? What's your family structure? What are your goals? Things like that. And then talk about what are some of the tools maybe available. The trust is just one tool, right? It's a very powerful tool. It's used many times, most of the times I would say. But it could be other variations of a trust, or it could be maybe a will plan or whatever, but there's other pieces to it. I wouldn't know exactly what to advise unless we have that conversation. And that starts with the peace of mind planning session. After that session, if we decide that we're a good fit, then we move on and we start the design meeting, right? We go to the next session where we start to design and craft exactly what it is based upon your needs and the different choices that you make, and putting and crafting that plan together. Then we have a document review session. We go over it, make sure that the strategy fits. Again, I'm definitely a person who likes to, measure twice and cut once, right? So we kind of go over it and make sure it exactly fits, your needs, answer all your questions, and make sure that, yourself and your family are all, sort of on board. And then we have a signing ceremony, right? And that's where we make it official. That's where we have a notary. That's where we go through and we make sure that everything is documented and legal. And then, from that point, you're good to go. And all of this, again, can be done remotely for your convenience. But again, it all starts with scheduling a peace of mind planning session. Someone said, can you convert a revocable trust to an irrevocable trust? You can't convert a trust, but what you can do is that you can recant that prior trust and then just start a new trust. So depending on exactly what it is that you're trying to do, we can definitely talk through that and see the goal of going from revocable to irrevocable. I think I'll leave it there because it can get complicated as far as, there are many types of trust, irrevocable and irrevocable, that do interplay with one another. And so depending on what your specific question is, we can talk about that in more detail. But yeah, you can't convert, but you can decant that one and then just start another one. But if you reach out to me, we can go over the details and see exactly what the need is. So 4 steps, and that usually can take depending about a month or so, going through those and making sure we have all the right documents and just going through things. So it can happen rather quickly. But a part of that too is, it is kind of like a 5th step. And one of the things is to keep in mind is once you have one created, it's fine, but you want to make sure that we connect at least every 3 years, because your situation may change. May have more children, may divorce, may buy more property, may whatever. Things may change. The environment may change. The laws may change, right? Someone may have a will or trust, they did maybe 20 years ago. Are there things that are still valid in it, or some things may be obsolete or whatever? You want to make sure it's updated. So you want to make sure even after you go through creating your estate plan or your trust, that you kind of have it reviewed by an estate planning attorney, at least maybe every 3 to 5 years, to make sure that nothing has changed. Okay. Any more questions? Feel free to send them to me via email, give me a call, or again, just set up a session and we can have a conversation. All right. Well, thank you, everybody. Enjoy the rest of your evening. Hope you found this helpful. If it did, please let me know. And definitely, I'm here for you to make sure that you have all the information you need to make sound decisions concerning your estate plan.